we should take funding a property on that purchase. Particularly in Ghana, we have a very astute lawyer, very experienced in the industry, and served many companies. There's so many transactions in the industry. He's here to do a presentation, and after that, we take a few questions for him. His name is Mr. Emmanuel Matthew. Please, run applause for him. Run applause. He says he likes facts, so you don't have to talk. So, one applause for him.
Thank you very much. I hope you can hear me. Right, next slide, please. So my name is Emmanuel Matikole. I'm the managing partner of MNO Law Consults, and I'm the head of the real estate infrastructure practice group. And I've assisted clients to buy property by conducting due diligence, by preparing legal documents, and registering their interest in these properties. Next slide. So essentially the essence of this is to show you how to secure your interest in land. When I say land, I mean bare land and also the land with the building on it. And then how you protect your property and prevent others from taking away the same. So essentially, these are the things that we are going to learn today. Next slide. So there are 3 stages of every transaction. There's a pre-closing stage, closing, and the post-closing stage. The same applies in jurisdictions like the US and the UK. In Ghana, it's important for you to go through these stages properly because we do not have something called title insurance. So in the US, they have devised an insurance which enables someone who has a defective title or who bought from someone who has a defective title the ability to get compensation, assuming that they lose their title. But in Ghana, we don't have that. So we cannot make mistakes. That's why we are doing this. In Ghana, you ought to ensure that you go through the legal process and comply with the law. So that when you go to court, the court will rule your favor. There is no insurance company to give you compensation, assuming it turns out that you have a defective title. So, next slide. So at the pre-closing stage, we are going to do due diligence. Due diligence. Next slide. Now, the due diligence commences with a search at the Land Use and Spatial Planning Authority. Ordinarily, people will always tell you that you start with a search of the Lands Commission, but the proper and appropriate place to start your search is at the Land Use and Spatial Planning Authority, and I'll tell you why. So the Land Use and Spatial Planning Authority is the authority responsible for devising the planning scheme of every area. So every area has a planning scheme. And there are certain areas where the authority has earmarked it for industrial purposes. There are areas that have been earmarked for civic and cultural purposes, like the National Theatre. Certain areas for commercial, residential, etc. The zonings are many. Now, if you take a grant of land, or assuming that you get a grant of land, and you intend to build a dwelling place, which is a house, on the land, and it turns out that the land has been used for agricultural purposes. What it means is that that particular grant is void. So assuming you come to, the client comes to me, and the client complains that somebody has taken possession of their land, the person is building. The first thing I'll do is I'll go and do a search at the Land Use and Spatial Planning Authority to find out whether the person can even build there in the first place. And if you cannot, you have that transaction set aside because the grant should not contradict the zoning of the area. So interest called a usufructive interest. It is something that you are giving. It's a right that you are born with, what you are born from that community. But now the law says that if you are not an indigenous and you can come off with and you live in the community for 50 years, you can acquire usufructive interest. These interests must be recorded at the customary land secretariat. These are customary interests. You ought to do a litigation check. And by the way, this is a limited slide, so we cannot show you everything here. But at least in terms of the series, you also do a litigation check to find out whether there is litigation on the land. Now, you ought to understand that as the society is developing, it is progressing. People are now becoming enlightened and more sophisticated. People who want judgments 30 years ago, because at the time, Thank you very much. So, what I was saying was that a litigation check is extremely important, and I explain why. You know, as the society evolves and people start realizing their rights, you realize that some people have won judgments previously. Let me take Adringano, Trasaco, that area. At one time, a certain stool, I'm not going to mention name, but a certain stool got judgment on those lands. Recently, a family has been given judgment on those lands. You see, if I go to court with you, the court will only determine my rights as against yours. They will only hear the two sides and determine that one person is right. But there might be somebody who has a better title or a better right, but that person did not come to court. But that doesn't mean that the person cannot come. If the person comes and the person is able to demonstrate with facts and evidence that they have a better title, the court will rule in favor of that person. So ownership can change. So if you don't do a litigation check to find out whether the people have been to court on the land and who won the case, then it means that you're not being prudent, because it's possible that another person has been given the allodial interest. So allodial interest means the person who was the first person to settle on the land. That person is the allodial owner. Allodial interest can change if you go to court. And if you go to court, and if you do a litigation check and you find out that allodial interest has changed, you have to go and look for the new owner of the land and enter into an agreement with them. And this is why. If you rely on the agreement with the old owner and you meet me in court and I have a client who has entered into an agreement with the new owner, what it means is that you, at the time that you bought your property, your owner did not have an interest in the land because of the court case. And maybe that would not have been recorded at the Lands Commission. So it's imperative that you do these checks. Then you also have to ask for the documents of the seller. So we are talking about judgments, site plans, indenture, etc. Recently, I was doing a transaction. A client called me, said he wanted me to do a transaction. I said, I won't do the transaction if there's no document. He asked me to call the seller. I called the seller, somewhere in Kumasi. The seller tells me that, I won't give you the documents. You have to pay the money first. And then I'll give you an allocation letter. And then I'll give you an indenture. And I told the client that I beg you, as for this transaction, I cannot do it. Because the law requires that before you make payments, you ought to look at the documents, the seller's documents. That is the requirement by law. So if the seller is not willing to give you the documents, it's a red flag. You don't pursue the transaction. Then, ground rent search, property rates, utility bills. It's important for you to confirm whether ground rent is owed, because by law, you are supposed to pay ground rent to the allodial owner. And the allodial owner is, like I said, the first person who settled on the land. If you don't pay ground rent to the allodial owner, the consequence is that the allodial owner can sell the land to somebody else, because it means that you are not atoning tenancy to them. If you are not atoning tenancy to the allodial owner,
it means that you are carving out a different interest. That interest is called adverse possession. And it's an interest that you can even go and register. So ground rent is very important. Property raised to utility bills, these are liens. If you don't pay the requisite authorities, they can sell your property and take out what you owe and give you the balance. Then, such as the National House of Chiefs is important because if you are buying stool land, you ought to find out whether the chief's name is gazetted. I think the office in Kumasi, if the chief is not gazetted, the chief cannot be signing indentures. He can perform all functions, but not formal functions like signing an indenture. So you need to find out whether the chief is gazetted. Etc. The traditional council is also important because there are sometimes boundary disputes amongst these communities, these stools, families, and all that. Previously, they were using rivers, banks, trees to ascertain or to locate the boundaries of the land. But when those things disappear, then it becomes a boundary dispute. So this is also very important. And then I search at the collateral registry to find out whether the property has been mortgaged. So these things are very important in order to show that you are being prudent. Because the principle here in our law is that buyer beware. It means buyer, go and do your checks. So if you choose not to do your checks and then you release $1 million or 100,000 cedis to somebody, then it means that you intended to be reckless. So the punishment is that. So the point is that you ought to buy from authorized persons. I'm not going to stay long on this. If it's the Q&A session, you can ask questions. If it's the stool, you buy from the chief. Family, you deal with the head of family. If it's the states, you deal with the lands commission. And then if it's the individuals and corporate entities, you ought to ensure that the transaction is done in accordance with the rules and regulations of the corporate entities. Let me give you an example. For instance, if the company's name is ABCD, and then in the indenture, the company signs the document and says, my name is ABC, it means that you've entered into a transaction with the wrong company. That's how serious it is. It means that you bought the land from ABC. You didn't buy the land from ABCD. And in law, because it's a corporate entity, the corporate entity is not the human being. It's separate from the human being. So if you go and transact with a company and you don't put the proper information on there, then they would presume that you are being reckless, like I said. Next slide. Now, something very interesting has happened in our jurisprudence. Now, initially, when you're buying land, you ought to state the renewal clause in the agreement. So if the lease is for 50 years, you ought to state that after the 50 years or after the expiration of the lease, you want a renewal for maybe 45 years. However, the law now makes it an implied term depending on whether you are an indigene, a citizen, or a non-citizen. Now, if you are an indigene and your lease expires, you are entitled to an automatic renewal where the lessee has developed the land for residential purposes, commercial or industrial property, and the term is for the same duration as the original lease. So for an indigene, you don't even have to put in a renewal clause. The law has put it in for you, impliedly. For a citizen, it's not the same. The citizen, it says that the automatic renewal will be applicable where the lease is in respect of commercial property or leased property for, no, so that you are entitled to an automatic renewal for a citizen. But if it is commercial property or it's leased for redevelopment, automatic renewal will not apply. Non-citizen, there's no automatic renewal, unfortunately. So I insist that whether you are an indigene, citizen, non-citizen, you ought to put in your renewal clause if you want an automatic renewal. Now, with the non-citizen too, apart from not being able to renew automatically, you cannot get a freehold interest in land. If you have a freehold interest, it will be converted to a leasehold interest. The leasehold is limited to 50 years for a non-citizen. And the only way that a non-citizen can fall into the category of a citizen is by establishing a company. That's the only way. So you establish a company and then you make sure that the company has at least 40% Ghanaian ownership. No, I think 40% foreign ownership. So the majority must be Ghanaian. Next slide. The closing stage. The closing stage is where you prepare the legal documents and you execute them. This stage is also as important as the due diligence stage. In fact, you can get everything right in the due diligence stage and go and get things wrong in the closing stage, and still the transaction will be void. So you can't get it wrong here. So the preparation of legal documents in Ghana, it ought to be done by a lawyer. And the lawyer must endorse the documents with the lawyer's stamp and address, so that if you take the stamp and address to court, and we check and we realize that at the time the lawyer was preparing the document, the lawyer was not in good standing, as in he had been suspended, then it means your document is void. So even for lawyers, you cannot prepare documents, a legal document, if you have been suspended or you've been disbarred. So it's important that you find a lawyer who is in good standing to prepare the legal documents for you. Now, the legal documents ought to be prepared in a certain way. The rule says that it has to be in writing. So if you go and think that you make an oral transaction and you think you've done the legal this part, you are wrong. It ought to be in writing, and it ought to be signed by the person who is selling or their representative. And if you do not follow these prescriptions, which is that the document ought to be in writing and signed by the correct person, then it means that the transaction is not enforceable. Let me just touch on this a little bit. I wanted to run, but let me touch on this. It's very important. You see, because if the land is stool land, the document has to be signed by the chief and witnessed by the principal elders of the stool. If it is family land, the document has to be signed by the head of family and witnessed by the principal members of the family. If it is a corporate entity, the document ought to be signed by at least 2 directors. So if you don't follow these prescribed rules, it means that your document is not enforceable. And I even advocate that when it's family land, you ought to, and even stool land, you ought to prepare a resolution where you have as many people in the family appointing the head of family and at least 2 witnesses to sign on behalf of the family. Because what happens is that there are cases where the transaction has been consummated and only 3 people collected the money. The head of family and the 2 witnesses collected the money and they squandered it. And no other member of the family benefited from it. Then they will take you to court to seek to set aside the transaction. And in some cases they succeed. Because when you sell family land, it doesn't go to, the money does not belong to the head of family. The beneficiary is the community, is the family. So if they do not benefit from it, they can have the transaction set aside. So it's better for you to make it as inclusive as possible. Although the law doesn't say so, but I'm saying that it's important that for added measure, you make it as inclusive as you can. Next slide. This concept is a very interesting concept, and it's a concept that a lot of people gloss over. So we all know land certificate. Everybody says land certificate, land certificate. But land certificate is not the ultimate. There are interests in land that override the land certificate. So if you think that you have a land certificate and because of that you are going to bully everybody, you ought to take cognizance of this. Easements and leases for terms of less than 2 years override a person who has registered their title. A government right of compulsory acquisition, you can have your land certificate, but government can pass an EI and essentially compulsory acquire your land and pay you compensation. And your rights in the land certificate, your rights will be extinguished. Rights of possession of persons in actual occupation. This is a provision that I have used a lot in court. This one has helped me a lot. So this one, it also applies to even spouses. If you are doing a transaction with a married person, you ought to ensure that you have both parties' names on every transaction, whether it be a mortgage, a sale, whatever. Because the spouse who does not sign the document falls in this category, rights of person in actual occupation. And they can have the transaction set aside. If you have a land certificate and there's somebody in actual occupation of the land, and you think because you have a certificate, you are going to have the person removed from the land, I'm sorry. This provision will stop you. A person in actual occupation's interest overrides that of one with a land certificate. In fact, in law, possession is key. The lawyers say possession is 9/10 of ownership. If you want a person who owns property, is the person in possession. You can only oust that person if you can prove a better title. A better title means you have a land certificate and you can also show that you were in possession and that it was interrupted. Says, I have mentioned that already. That gives an overriding interest. And then property and utility rates too. Those that you owe, also have an overriding interest, or they have liens. They are called liens on the property. Next slide. We're almost done. So the key takeaways, here's a short presentation, are that first you ought to conduct a thorough due diligence on the land. You buy from authorized persons, obtain the requisite consents, and register the land. And I entreat you that you should remain vigilant and approach every transaction as though you were dealing with a dishonest person. Next slide. Now, as lawyers, when we identify problems, we also try to create solutions. So, we also devised a way of doing a transaction in such a way that we take out the individual parties and we stick to the rules. So, essentially, we came up with an escrow arrangement in which the purchaser would more or less transfer all the money into the escrow account. So it means that the purchaser will not have that money to be given to the seller, because we noticed that while the lawyer is doing the transaction, the buyer and the seller are talking, the money is being transferred. By the time you tell them that, hey, there's a problem with the property, oh, lawyer, I finished paying the money. I'm like, what? You finished paying the money? How? So if the money is in an escrow account and the checks have not been done, we are not going to pay. Then this arrangement also allows us to use other professionals like surveyors, building inspectors, valuers. The reason why building inspectors, etc. are important is because we rarely do structural integrity tests in Ghana. A lot of these things are taken for granted, but these are very important things. In the developed world, these things are key. And we have something called a building code. A lot of times you go around and you see people who have built close to the wall. That is an unauthorized building. Your building is supposed to be 3 meters away from the wall. 3 meters is a gap. You know, you are not supposed to build too close to the wall, such that when your building falls down, it will enter the other person's compound. It's not supposed to be done. In fact, there should be so much space around your building that the fire service can drive around the building, but you rarely see that. Anyway, I have sued a number of people for that, and there are cases that have managed to demolish some houses. So it's a very serious thing. Then, obviously, the drafting of the documents, we want to ensure that it's done in accordance with law. Like I said, the transfer is done in accordance with law. Stamping and registration is done in accordance with law. Let me give you an example. So there's a law. I mean, the law is that, I'm not going to say the new law because it's been in existence for 5 years. But the law is that when you are selling stool, skin, clan, family land, you ought to seek the consent of Lands Commission. Yes, before the land can be registered. I'm yet to see registration being done where they are asking for Lands Commission's consent in respect of family land and clan land. For stool land, it's normal because it's in Article 267 of the Constitution. So they've always done it. For stool land, Lands Commission consent has been sought, planning comments are obtained, and the registration is done. But then the law has now included family land and clan land as part of the requirements for it requires that they comply with Article 267 of the Constitution, which requires that Lands Commission gives its consent, but the lands are being registered, and Lands Commission's consent is not being sought. And the law says that you should not register the land if it's family land, clan land, if Lands Commission's consent is not sought. But yet it is being done. And a time will come when people will go to court and set aside land certificates because this consent, which is mandatory and is in the Constitution, has not been sought. So these are very critical. So in a nutshell, I mean, this is how I believe you can secure your interest in land, which is by conducting due diligence, by preparing the documents the proper way, and by registering them. Please, do you have any questions?
Thank you very much. Please, a round of applause for lawyer. Let's do a bigger one for him. All right. I do have a few questions before I engage everybody else. So one of the slides, I think if you can go back a bit. Slides, if you can go back a bit. There was something that, yes, go back a bit. And I think one more. Yes, the easement and lease terms. If you could explain a bit more on that.
Oh, good. So that's what I'm expecting. But the law is very broad, so I can't explain everything. But once you hone in on it, I can explain. Good. So easements are what we call right of way, right? So let me say that place is your house, right? That thing, that structure is your house. Now I'm supposed to use this path to enter your house, right? So after I use it for a number of years, it now becomes an easement, a right of way. Yes. So if you allow somebody to use your house, the inside of your house for a period to enter their house, it becomes an easement. And the easement, there's the one who benefits and there's the one who suffers. So the one who benefits remains the dominant tenement. I don't want to use those terms, but basically there's a master and a servant. So the one who enjoys is the master and the one who doesn't is the servant. And you cannot decide to just change an easement because the person is buying the property because they know that they are going to enjoy the right of way to their home. So you cannot just come and block an easement. So you can go and take a land certificate and then I will come and tell the court that this is an easement. You should have taken a certificate over it. Yes, because and a lot of times. If it's allowed over a period, it becomes an easement. But you realize that sometimes a right of way could also be a road. But sometimes people even come and build in the middle of the road. And that is an unauthorized building because an easement, without that road, people cannot enter their homes. And they bought it because they saw that there was a road there which would enable them to enter their home. That's why they bought the property.
So, places that get demarcated there are a number of houses on that day. But sometimes you find somebody build his house and extend towards a road or a waterway or something. We've all seen it many times, right? Now, if the assembly is not doing anything about it, or the authorities are supposed to do anything about it, you clearly know that that's a road. And anybody in the committee on their own accord, go and break that wall or
No,
try
no,
and
no,
enforce that.
no,
What's the way
no.
around
That
it?
that will be a criminal offense. Yeah, you cannot be breaking down
What's the way
because
around it?
you
Sometimes
need
the authorities are aware.
yes, you need a demolition permit before you can demolish anybody's building. But in my case, what I do is that I will sue the culprit. That's the person who is offending the rule. And then I will sue the assembly. You see? And then I will ask the court to make an order for the assembly to direct the assembly to do the demolition. So even when you make that, when you sue the assembly, and sometimes even the assembly comes to court and then they respond. You know, when you sue, they'll come and respond. When they respond, based on their response, sometimes the culprit knows that they are wrong, so they will even go and do the demolition themselves. Because based on the response, because if the assembly comes and they say it's true that what you have done is wrong, there's no way you can win the case. Uh-huh. Yeah, sometimes the institutions are inactive. They don't want to move, so you have to force them to move. So you have to compel them. You go to court, you take them to court, you do it a number of times, then they are now alive to some of their responsibilities.
Yeah, thank you. So, can you please shift a bit? The same slide you were on when,
The Eastbend slides.
Yes.
Slides, please go back a bit.
yes, my name is
No.
Martin.
Come forward one.
Yes.
Yes, right here.
The third point, rights of persons in actual occupation. I want to know to what extent this applies to squatters, and to what extent, if even the person is not a squatter, maybe you give the person permission to stay on your land for a while, and there is difficulty ejecting the person. To what extent does that apply to this point? Thank you.
So you are talking about rights of persons in actual occupation. That is separate and distinct from adverse possessors. I just want to draw a distinction for you. So a right of a person in actual occupation could be somebody who is there legally. Do you understand? But maybe in the process of conveying the property, that person's presence was not like acknowledged. You didn't see them to sign documents, nothing. So they have an overriding interest. But then when you talk about adverse possession, that is where the squatters comes in. So a squatter is somebody who is not there legally. That person is illegal. You see, that person is a trespasser in law. Now, if you watch a trespasser on your land for 12 years or more, then it means that you have acquiesced, like you have accepted that this land here, I don't want it again. This guy, take it. I hope you understand. So if you allow a squatter to stay on your land for 12 years or more, then the squatter can claim adverse possession. If you can demonstrate to the court that the time did not run because you accosted the squatter, you reported him to the police and all that stuff, then maybe you will not fall under adverse possession. But if you cannot, then adverse possession is a defense, and it's an overriding interest.
Sidamba, and my question is, what are the most common clauses missing from standard sales and purchasing agreements that have caused most of your clients' problems, and what do you insist on being included in those documents?
Okay, so it's a very good question, I must say. Now, I'll give you a direct answer before I continue. Now, what business do you have drafting a contract if you are not a lawyer? You get me? Let me give you my personal experience. I like to give you practical examples so you understand. Because if I just talk, you will not understand what I'm saying. A client comes to me like 5 years ago, and then he says he's paid money to somebody to build a house for him. The person has built the house, but they're refusing to give him the house. I go through the contract. I realize that there's nothing in the contract which says that when you finish the house, you should deliver the property to the person. There are so many things that were missing in the contract. No default clause, nothing. So we went to court. And the thing is, lawyers, we lose cases not because we are not good, but because your client has a bad case. But because you're a human being and the clients will come to you and let me see what I can do for the client. So I showed the judge asked me, lawyer Matekoli, are you the one who drafted this contract? I said, my lady, no, I didn't draft the contract. So now, eventually you won the case, but the judge had to import covenants that are in the conveyancing act to help the client. You see, because there was nothing in the contract that that was supposed to. But you see, if you go to a lawyer is using standard provisions based on disputes that have arisen. A lot of disputes have arisen over time, and based on that, we have a standard template that we follow. And there are certain things that we put in the contract: indemnity clauses, breach clauses, termination. All these things are in there. So if you see the right professional, most of the areas will be covered. But if you stay in your room and you draft it by yourself, then danger.
Yesterday she was here as well. She has a very, very big question I'm going to explain today as well. She's been participating in this. The other question I wanted to ask you. For the most time, we've always believed that the land title is the highest form or the ultimate form of any documentation you have. But there have been instances where it's set aside. And you gave examples where the land title was set aside. So how sure can you be sure? And what more can you do to say that I'm acquiring a property, I'm paying, and what level of documentation should you be confident that they do? Also have one title, it can still be set aside because of so many other reasons. What more can you do?
So let me explain something to you. You see, the courts, let me just use the word advisedly, are not ignorant. Like they know that people intend to be fraudulent. They know. Do you understand? Like the court, they are not babies. They've been there for a very long time. So what the court is looking at is, did you act in good faith? The question is, did you act in good faith? How do you demonstrate that you acted in good faith? By following due process, by conducting your due diligence, by doing all of these things. Now, if you bring a land certificate to the court, and then we do a search, and we find out that, but this your certificate doesn't make sense. Even the person you bought from, they haven't registered. How can you register? Because you see, if I buy from you, and you transfer your interest to me, and you haven't registered, I should not be able to register. But in Ghana, people will transfer interest to you, and the law says you should not be able to register, and they will be able to register. Yes, they are able to register. So what is your registration based on? Because pardon? You see, you cannot give what you do not have in law. If you don't have a registered title, you cannot give me a title that I can go and register. I hope you follow me. So when a person buys the property and the person is going to sell to you, you have to ensure that the person registers before they sell to you. Or they should go to the person they bought from who has registered, so that person will transfer it to you, so that you can go and you can have a registrable interest. Otherwise, you cannot register. But you have situations where, big companies, then they will come, land certificate, you go to your documents, hey, this one magic or what? You see, so when that happens, and then you present it before a judge, and the judge, this one, you can't help the person. Do you see? Then they'll say the judge is corrupt or something. But I mean, if the thing doesn't make sense, you cannot let it go. You ought to go through the process. You see, land certificate is just one document in the process. The things I showed you, the searches, you're supposed to keep them in your safe. So that when the time comes, you produce them that, look, I did this, I did that, I did this, I did this, I did this. Then they are all as important as the land certificate. But you decided that out of the 20 things I have said, you are going to pick land certificate. Hey, hooray, I'm done. Oh no, it doesn't work that way.
In relation to adverse possession, so a trespasser is on my land, and he or she had been on the land for 6 years, and I tried to eject him or her, and unfortunately, I failed. In your submission, you said it should be on the land for 12 years. After the 12 years, does that mean that I lose my possession automatically, or there are other remedies?
How did you fail? How did you fail?
How do I fail?
No, how did you fail? Like, what happened? You said you failed. You tried to eject them and you failed. What happened?
Maybe
You have to be, like, answer the question. Don't speculate. Because if you speculate, answer it.
No, so assuming I tried to eject him, and then he refused to go. In my own capacity, trying to use my own ways and means to eject him, and he refuses to go, and I left him, and then I went back. After 12 years, do I lose possession?
So it means you did not fail. You see, the thing is, you ought to demonstrate that you yourself, you are a law-abiding person. A law-abiding person will attempt to eject somebody, and if it doesn't succeed, you go to an institution, to maybe the police to report, or you go to the courts. Do you understand? Like, you ought to follow, it has to follow a certain logical sequence for us to see that you are serious. But if you go to the court and you tell the court that I try to use my own authority to remove the person, and the court says, okay, so, and the person did not go, so what happened? And you're like, oh, so nothing happened. Now they'll ask the other party, what did he do? The other party will say, he didn't do anything. He didn't even come. It's your word against the other party's word.
So the burden of proof will be on you
to prove that you and there will be nothing to show because you didn't report, you didn't do anything. So it will just be your word against the other party's word. And the other party will win because they are in possession. But you have nothing to show that you sought to remove them.
Okay, so does that mean that I'm going to lose my possession automatically, or there are other remedies for me?
After the 6 years?
After the 12 years.
After the 12 years, once you've allowed 12 years to run, it means that you've lost your interest. Your rights have been extinguished.
So it means I'm going to lose it automatically.
Yes. But why would you sit down for 12 years?
No, it's a question I'm asking based on...
Yeah, I mean, that's what I'm saying. Because the court too, they are not babies. Like, what if you are serious? Why would you sit down for 12 years? 12 years is a long time. Oh. A baby will be 12 after 12 years.
Because that's what the law requires. It's after 12 years.
That's what I'm saying. But you don't have to wait for 12 years. You can be chasing them to leave every year. If you are serious, every year you can be chasing them to leave. So 12
and show
years,
the courts evidence that you're chasing them.
Exactly. 12 years is a long time.
Right, then there was a hand here.
Can I come again? Yes. So it means that at the 11th year, I can try and then eject him.
Why the 11th year?
No, because that's what the law says. The law says
no,
after
the law
12
doesn't
years.
say that you should wait for 11 years. The law is saying that you have to be, you shouldn't sleep. Don't go to sleep. If you go to sleep, the law will punish you. That's what the law is saying.
Lord, maybe he wants to take somebody's land rather. So he's trying to find a trick.
No, you see, I'm only asking the question in relation to what the Land Act is saying. Because the Land Act says that after 12 years.
The Land Act doesn't say so. It is the Limitation Act.
Fair enough. Fair enough. So meaning it should be after 12 years.
After 12 years,
Yes.
if you cannot show that you took steps to remove the encroacher, then the encroacher can claim adverse possession. But you see, adverse possession is a sword as well as a shield. That means the other person has to come and say that they are an adverse possession before the court will give it to them. If they come and they don't say adverse possession, then you'll be lucky to have your land back. Yeah.
Thank you very much.
All right. Thank you, sir.
Good afternoon. My name is Zain Mohammed. Yes, I wanted to ask, one thing I've identified with regards to purchase of land, why a lot of people buy lands without maybe requiring professional help, or like the example she gave, where they draft their own contract and all that, is because when people hear lawyer, they start thinking a lot of money. So I wanted to know, for instance, if I'm buying a land that values around, let's say, 15,000 cedis, and I want to do the right thing, how much should I expect to spend when I want a lawyer to go through all the processes to make sure that I'm buying a genuine land? How much should I be thinking of to prepare before? Because if I'm holding 15,000, I shouldn't be thinking that 15,000 is what I'm spending. I should maybe think that I should have more than that so that I can do the other stuff before.
Okay, so this is also a very relevant question. I'm happy you asked this question. So you see, for me like this, before I represent you, I'll ask you to show me the seller's documents because I need to know the scope of work. If you bring me a document, let me give you an example. Somebody came to see me. They said I should represent them, and I told them, I need to see the documents. They insisted, there's the land certificate, there's that. Give me a fee. So I said, okay, I'll give you a fee. I gave the person a fee. They brought the documents. I read the document. I realized that the lease had expired. It expired in 2013. So if the lease has expired in 2013, it means that the scope of work I gave you is wrong. Because it means that we have to go back to the seller for the seller to renew before you can even buy. I hope you understand. So if I don't know the scope of work, it's not about the money, it's about the scope of work. If I don't know the scope of work, so if I ascertain the scope of work, and I tell you that this will cost 100,000, and the land is 50,000, the obvious choice is that you shouldn't buy the land. If the fixing the problem is more expensive than the land, then unless you have the money or you are emotionally attached to the land, then don't buy it. Because as for the professional, they will charge you. They won't do the work for free. Do you see?
Any more questions, please? Any more? There's one here. Thank you.
Okay, thank you. Please, in relation to the encroachment, can a caretaker, somebody you left your land with, maybe you were traveling, so you left your land with him to take care of it. After 12 years, can he also claim the land? Is there any law that covers him? Because I've heard of something like
use
that.
the expression caretaker.
Yeah, the person is a caretaker. He just left the place for him so that...
So caretaker, it means that person is your caretaker, right?
Yeah.
So it means that the person is there at your instance.
Okay.
They are there with your permission.
Okay.
You cannot be in adverse possession if you are there at somebody's instance or somebody has put you there. But if you are there and you are fighting the actual owner, then you are in adverse possession. That's why we call you squatter or trespasser, because you are asserting an interest which is adverse to that of the real owner. But a caretaker is not asserting an interest adverse to yours. The caretaker is actually there at your instance.
Okay. Yeah. Come again.
Any more questions? Anybody with another question? Law is the law. Final question from me. So the slide is talking about people not willing to release documents at the search stage. There've also been a number of instances where people have released all their documents and before I realize people are doing fraudulent activities with it or even attempting to do the transfer without payment. Are they, for want of a better word, trying to protect their interests? How much are they allowed to also want to protect their interests by not releasing documents?
So when I say you ought to show your documents, I'm not the one saying it. That's the law. You see, the law says you ought to share copies of your documents with the prospective buyer. That's one. Number two, if you follow the law, it will be quite impossible for somebody to, or almost impossible for somebody to fake your documents. The reason is that assuming you have registered your title at Lands Commission, and then you share photocopies of your documents, without the originals, Lands Commission cannot do any transaction on your land. Do you understand? unless the person is able to get certified true copies. And certified true copies too, the person must be able to cite the original before they can certify it as a copy of the original.
How about scanned copies? Scanned copies.
Yes, scanned copies are copies. Now, if the person is able to replicate it and register it at Lands Commission, then that is where we also have to check what process they followed to get that registration done. Do you understand? And let me tell you something. It is not your copies that will make somebody go and forge your documents. So there are people who are doing the forgery. We know them. We will see it. But it's not your documents. If you want to forge, you will forge it. All right, so just follow the law.
All right. Thank you very much.
Yeah.
All right.
Hello. Yes. Says my name. I just want to piggyback on the question she asked about the caretaker. What if you leave to the caretaker for more than 12 years, then now you ask the caretaker to vacate the place and the person doesn't want to? What happens then? Does it become an adverse possessor of the place or what?
The moment the caretaker told you that he is not leaving, that day his adverse possession hasn't started, but time starts running.
From when it tells you?
The 12 years, day one will start.
Okay.
Day one of the 12 years starts.
Okay, all right.
But then that would mean that you have to take him to court to remove him.
Okay, all right. Sure, thank you very much.
So adverse possession is after 12 years. But within the 12 years, the person is not in adverse possession. But the person can raise things like lashes, acquiescence, and some other principles.
Okay, thank you.
All right. So we want to wrap up this session. I'll take the last question, very last question, and then we are done here.
I'm a land surveyor. There are instances where there was a case adding to my brother's own. There was a caretaker who, after the actual owner of the house, asked him to move out because he would evict the place. He was now demanding, requesting the owner to pay him some unagreed amount of money. Although the owner initially thought he was helping him have a place to stay, but now he was asking him to pay him a huge sum of money before he moves out. So what happens with that? There was no agreement, such agreement initially. He was just trying to help him initially. So it has actually become a situation, a big situation. I want to find out.
Anyway, I mean, these things do happen, but I would, first of all, I would report them to the police. There's a unit called Property Fraud Unit. Because if you are there at my instance, and I've come and I say, hey, vacate, and you say, I will stay, and I want to give me, it looks more to me like extortion or something like that. So I report to the police. Eventually, maybe we'll end up in court. But these things happen. And for me, I advise my clients that if somebody's in actual occupation of your land and you want the person to vacate the property because you are selling it, I think it's only fair that you give them something small. Do you see? Something small, because you must understand that they also have some accrued interest. Like even though it's not for them, you've changed their circumstances, so you ought to compensate them just a little, and you leave. Then you also have to punish him. But other than that, I think you should be able to speak to the person and compensate them. Yeah.
I think this is a special round of applause.